Incorporation, which is the process of applying provisions of the Bill of Rights against the states in the same way that they have always been applied against the national government, is a central feature of the larger story of the development of civil rights and civil liberties in the United States. We have to remember that the Bill of Rights starts off with "Congress shall make no law," implying that the subsequent rights limit the national, not the state governments. As we'll see in these sections, the ideas of incorporation of the Bill of Rights start off in the early Republic, but are uniformly rejected. Chief Justice John Marshall, as you'll read, quickly disposed of the issue by saying that while applying the Bill of Rights to the states is an interesting idea, it's nevertheless incorrect. It would not be until the ratification of the 14th Amendment in 1868, though, that those who supported applying the Bill of Rights to the states believed that they finally had a textual provision that would help them. The 14th Amendment, passed during Reconstruction, announced 3 limitations against state governments. States now cannot deny to their citizens due process of law, could not deny to them their privileges or immunities, and could not deny to them the equal protection of the law. As we'll see, proponents ultimately seized upon the Due Process Clause of the 14th Amendment to argue that a violation of the Bill of Rights by states constituted a violation of due process. This process was fraught with difficulties and challenges, and even to this day, not all of the provisions of the Bill of Rights are applied against the states. The Third Amendment is not applied, nor is the grand jury requirement in civil cases in the 7th Amendment, nor is the excessive bail guarantee of the 8th. In fact, the current court, and every court since, still does not accept the idea of full incorporation. But there have been 4 approaches that the court has taken. One is total incorporation. Some will argue that incorporating the Bill of Rights against the states is not only fair, but an important way to limit judicial activism. Civil rights and civil liberties is at its most controversial when justices announce new rights or interpret existing rights in different ways. By incorporating the Bill of Rights completely, with no exceptions, some, like Justice Hugo Black, believed it would prevent the court from committing the sin of the previous Lochner Court, where they read new provisions into the Constitution that were not explicitly enumerated. Others have a selective incorporation or a preferred freedoms model. In this understanding, which a majority of every court has adopted, only those provisions of the Bill of Rights that are deemed fundamental and rooted in a concept of ordered liberty are applied against the states. Derived from the Palco case in 1937 that you'll read, the justices simply ask which provisions in the Bill of Rights are so fundamental to an ordered society that if we took them away, the entire system would fall apart. So, for example, free speech falls into this category, but jury trials in civil cases do not. Another approach is fundamental fairness, which was made famous by Justice Frankfurter in the Rochen case. This is pretty similar to selective incorporation model. If you remember, in Rochen, police involuntarily pumped the stomach of a suspect that they believed had just swallowed drugs. Frankfurter believed that while this was unconstitutional, it wasn't because the Bill of Rights were applied against the states, but because the actions of the police, quote, shocked the conscience and were fundamentally unfair. Finally, there is the selective incorporation plus other fundamental rights approach. Here, the court selectively applies provisions of the Bill of Rights based upon the ordered liberty model, but also would include other unenumerated rights that would apply to the states. We see this approach most conspicuously in Griswold versus Connecticut, where the court announced a right to privacy that was now to limit state governments. So as you read these cases, think about these points. While incorporation is not mentioned in the text of the Constitution, most of us think that the Bill of Rights should limit state governments in the same way that they limit the federal government. Are we simply wrong? All of these models of incorporation place the decision about which rights should be incorporated with the court. One model even goes further, in that the court can announce new rights that apply. How do you feel about this? Should an unelected judiciary be the institution that makes such important decisions? Or is the judiciary the best institution to make those important decisions? Which model of incorporation makes the most sense to you? Incorporation necessarily affects issues about federalism also. How much leeway, if any at all, should states have in this debate? Should they have the power to enforce or apply more or less of the rights enumerated in the first 8 amendments? Is it true, as the court said about incorporation in the 1880s, that we have different rights as state citizens than we do as national citizens? These are some of the questions that we'll think about, work through, and debate as we talk about the incorporation of the Bill of Rights.